Yes, Varsha, we are good to go.
Yes, thank you. A very warm and colorful evening to one and all present here. I am Varsha, a student of second year LLM, and I welcome you all to the day 5 session of online lecture series on Civil Procedure Code 1908, organized by the Karnataka State Bar Council Law Academy. I believe that most of us will be having a preconception that Monday represents a fresh start to the week, and it's a day where the slate from the previous week is wiped clean and it's a day of new beginnings. I hope everyone gathered here had a great weekend and kick-started your day well. With this note, I would like to begin with a quote given by Leonardo da Vinci. He says that learning never exhausts the mind, and so the pursuit of knowledge is a never ending process. So let's keep on learning and enhancing our knowledge. And now it gives me immense warmth and great pleasure to grace the presence of our esteemed dignitary, Honorable Justice N. Kumar, retired Judge of High Court of Karnataka. Welcome, sir. I also welcome all the members and trustees of KSBC Law Academy, along with its president, Sri Gautam Chand SF, and Sri Anil Kumar JM, chairman of KSBC Law Academy. Also, I would like to extend my heartfelt welcome to all the delegates, guests, advocates, law students, and participants who are continuously supporting us. Friends, feel free to post your questions in the chat box, and sir will be addressing them during the question and answer session. Without any further ado, I would like to welcome back our distinguished dignitary, Honorable Justice N. Kumar, who will be enlightening us on the topic written of plaint and rejection of plaint in today's session. Welcome, sir, and the platform is yours.
Thank you. In the last session, we saw what a pleading means, how to draft a pleading, what are the ingredients which constitute a pleading. We also saw Order 7 Rule 1 categorically states that the plaint shall contain the particulars mentioned therein. That is, shall contain. No option is given. 8 particulars are mentioned in that provision. One such provision, which is relevant for today, is a statement of the value of the subject matter of the suit for the purposes of jurisdiction and court fee, so far as the case admits. So therefore, every plaint should contain a statement regarding the jurisdiction of the court to entertain the suit, and also a statement regarding the court fees payable on that memorandum of plaint. This is a mandatory requirement because Order 7 Rule 1 says the plaint shall contain. Now, the question is, if those particulars are not mentioned, or if that particulars is wrongly mentioned, what would be the consequence? Because it is a question of jurisdiction. We have discussed earlier the jurisdiction of the civil court is of 2 types. One is pecuniary jurisdiction. Another is territorial jurisdiction. If the civil court has no jurisdiction, then it is not competent to try the suit, and any judgment and decree passed with that court would be a nullity. Therefore, it is incumbent on an advocate to make sure that he is presenting the suit in a court which is competent to try, in other words, which has jurisdiction to try this suit. Now, 2 things he has to keep in mind, that is pecuniary jurisdiction and territorial jurisdiction. Now, if a plaint is presented to a court which has no pecuniary jurisdiction, which has no territorial jurisdiction, what the court is expected to do? You can't prevent a party or an advocate from filing a suit. Once the suit is filed in the office, it is brought before the judge. Now the question is, what is the judge is expected to do? When is he expected to find out whether he has jurisdiction or not? So it is that part of the law which is dealt with in Order 7, Rule 10, that speaks about return of the plaintiff. Mark this word, return. As opposed to this, Order 7, Rule 11 speaks about rejection of the plaintiff. So what is the difference between return of a plaintiff and rejection of a plaintiff also should be kept in mind. Now first let us deal with return of plaintiff. Order 7, Rule 10 speaks about return of plaintiff. It went an amendment in 1976. Prior to amendment, the law was the plaintiff shall at any stage of the suit be returned to be presented to the court in which the suit should have been instituted. So therefore, if an objection regarding jurisdiction is taken, an obligation was cast upon the court to go into the question of jurisdiction at the earliest point of time. And if the court holds either it has no pecuniary jurisdiction or it has no territorial jurisdiction, it can't dismiss the suit. It has to return the plaintiff to the plaintiff to present it in a court which has got jurisdiction. This is the principle. In 1976, an amendment was made to this by introducing Rule 10 capital A. So that is the amendment. Now the rule reads, subject to the provisions of Rule 10A, the plaintiff shall at any stage of the suit be returned to be presented to the court in which the suit should have been instituted. So therefore, let us be clear about it. Jurisdictional aspect has too many grounds. But Order 7, Rule 10 is only concerned about a territorial jurisdiction or pecuniary jurisdiction. Otherwise, it is not a case of return of plaintiff. Return of plaintiff arises only when the court has no either territorial jurisdiction or pecuniary jurisdiction. When we say this jurisdictional aspect, last occasion we saw that every suit shall be instituted in the court of the lowest grade competent to try it. That's how the section 15 reads. So therefore, a lawyer who wants to present a suit should bear in mind which is the lowest grade, which is the next grade, what is the difference, how do you decide it, is an exercise which the lawyer is expected to do before he decides to present claim. As I said, the word pecuniary jurisdiction is defined under Section 6 of the Civil Procedure Code. It says, save insofar as is otherwise expressly provided, nothing herein shall operate to give any court jurisdiction over suits the amount or value of the subject matter of which exceeds the pecuniary limits, if any, of its ordinary jurisdiction. Now, insofar as pecuniary jurisdiction is concerned, we have to keep in mind two enactments. CPC itself does not speak about the pecuniary jurisdiction. It only defines what a pecuniary jurisdiction. To find out whether a particular court has got pecuniary jurisdiction or not, in the first place, we have to look into the Karnataka Civil Courts Act of 1964, where it has been categorically held the pecuniary jurisdiction of a civil judge is less than 5 lakhs, the value of the subject matter. If the value of the subject matter is above 5 lakhs, it has to be presented before a civil judge, senior division. That is the distinction as far as pecuniary jurisdiction is concerned. Now again, there may be a dispute regarding the valuation. That is, the plaintiff will value the subject matter as 4 lakhs. So if it is 4 lakhs, it has to be filed before the civil judge. He files it. After service of summons, the defendant enters appearance. He has a right to say whether the valuation is proper or not. He would say, look, the plaintiff has not properly valued the suit. The value of the subject matter is not 4 lakhs. The value of the subject matter is 10 lakhs. And therefore, this court has no jurisdiction. Once such a statement is made in the written statement, since it's a question of jurisdiction, an obligation is cast on the court to frame an issue. So therefore, the court will frame an issue whether the plaintiff has valued the suit properly, or it may be shown whether the plaintiff showed the subject matter valuation only 4 lakhs, or it may also say whether the defendant proves that the value of the subject matter suit is 10 lakhs. Anyhow, that's a question to be gone into. Now, Order 14 Rule 2 further says all the issues have to be decided at once, subject to Sub-Rule 2 of Rule 2 of Order 14. What Sub-Rule 2 says? Decide all issues, but if an issue which arises for consideration is purely a question of law, and that issue relates to question of jurisdiction or maintainability of the suit, that issue will be tried as a preliminary issue. So, question of jurisdiction, pecuniary or territorial, Order 14 Rule 2 is clear. Order 7 Rule 10 is also clear. Courts have no jurisdiction. Therefore, an obligation is cast on the court to decide whether that particular court has a pecuniary jurisdiction or not. If evidence is required, evidence is to be taken. After recording of evidence, the court has to positively give a finding whether the value of the subject matter, it may say it is not 4 lakhs, it may be 4.5 lakhs. If the claim is it is 10 lakhs, it may say it's not 10 lakhs, it is 6 lakhs. But it has to give a finding. Most of the time, it deals with immovable court. Today, there is an advancement of law because of this. One is valuation is not properly given for the purpose of registration. Another is valuation is not given properly to avoid payment of court fee, avoiding paying court fee, avoiding paying stamp duty. Therefore, the government has done every property which is to be registered at a particular sub-registrar rate, they have what is called as a sub-registrar rate. So, it is all duly published in the Gazette. So, that is a piece of evidence in the absence of any other evidence, because most of the relief sought for under the Specific Relief Act or under the Transfer of Property Act, the valuation is made under the Court Fees Act, and there either it is on the basis of the consideration mentioned in the instrument or it is based on the market value of the property. If it is on the basis of a consideration mentioned in the agreement, consideration is there. It shows whether it is less than 5 lakhs or above 5 lakhs. That is, if it is in terms of the agreement of sale, when you are seeking for cancellation of a document. But if it is a case of declaration of title, recovery of possession, ejectment, in those circumstances, though the consideration mentioned may be 4 lakhs, property is purchased 20 years back, the question is what is the market value of the property on the date of the suit? So on the date of the suit, you can find out what is the market value by referring to the sub-registrar rate. That is a piece of evidence. Even otherwise, parties are at liberty to produce documents of near period which show at what rate the properties are sold. So that gives a clear indication of the value of the subject matter of the suit. After this inquiry, it is open to the trial court to hold either it has jurisdiction or it has no jurisdiction. But let me make it very clear to you. All that the court can say is that it has no jurisdiction because the value is more than 5 lakhs. If it is civil just senior division, they can say value is less than 5 lakhs. That court has no jurisdiction to decide which court has jurisdiction. The court which has jurisdiction to entertain the suit is to be decided by the party. Court can only say whether it has jurisdiction or not. Even by mistake, if they say go and present it in some other court, party is not bound by it. Party should not take legal advice from judges. Party should take advice from his lawyer and they should decide if this court has no jurisdiction, which is the court which has jurisdiction, and it is for them to decide in which court the plaintiff is going to be represented. So therefore, this is about pecuniary jurisdiction. As far as territorial jurisdiction is concerned, again we saw section 16, where it is categorically stated suits to be instituted where subject matter is situated. Subject matter is immovable property. It is situated in a particular village or a taluka or a district. Every court has a particular territorial jurisdiction. And therefore, that court will be called upon to decide, in the case of a dispute, whether the property is situated in an area over which that court has jurisdiction. Here also it can say, I have no jurisdiction. It is not situated within my jurisdiction. You should not embark upon an inquiry to find out that property is situated in which court jurisdiction. That is beyond the scope of inquiry. Once they say it is not within my jurisdiction, I am going to return the plaint. It is for the plaintiff to inquire, find out which court is competent to entertain the suit, or find out in which area, village, taluka, that property is situated, or which civil judge court has jurisdiction, and then go on present. So this is the exercise which a court has to do when an objection regarding either pecuniary jurisdiction or territorial jurisdiction is raised in the suit. Now, the question arises, the section 710 says the subject to the provisions of section 10A, the plaintiff shall at any stage, mark this one, at any stage of the suit be returned to be presented to the court in which the suit should have been used. At any stage. What are the stages of a suit? First stage is the filing of the suit. Second stage is the filing of the written statement. Third stage is the framing of issues. Fourth stage is the commencement of recording of evidence. The next stage is arguments. And the last stage is judgment. So, from the moment it is presented till the judgment is passed, at any stage, the court has the power to return the plaint for presentation to the proper court. When that is the law, how this, at what stage this objection is to be raised? That is the power of the court to return it at any stage. At what stage the party should raise that objection? That is, the defendant should raise that objection. For that, we saw section 21 of the Civil Procedure Code, where an embargo is imposed on the appellate court to interfere in these matters. That will give an indication when this objection is to be raised. For example, 21.1 spoke about territorial jurisdiction. It said, no objection as to place of suing shall be allowed by any appellate or revisional court unless such objection was taken. Objection was taken in the court of the first instance. So this objection should be taken in the court of first instance at the earliest possible opportunity, and in all cases where issues are settled at or before such settlement, and unless there has been a consequent failure of justice. Same thing with the pecuniary jurisdiction. So at or before settlement of issues, at the earliest point of time, this objection should be taken. If it is taken, an issue is framed, and that issue is tried to the preliminary issue, and therefore this question of jurisdiction could be sorted out before the trial in the suit begins, so that no time is wasted. No time is wasted. So therefore, once this court holds it has no jurisdiction, then the law says you return the plaint. Return the plaint to whom? Return the plaint to the plaintiff for presentation to the court which has jurisdiction. Now the question is, once the plaint is returned, plaintiff receives the plaint. He has no option except to go and file to the proper court. Now this order, returning the plaint, is an appealable order under 43. The plaintiff may say the argument or the stand of the court is not correct. It has jurisdiction. Then he has to challenge that order in the appellate court and contend this order is erroneous. If the appellate court accepts his contention and set aside the order of the trial court, the suit will go on. But if the appellate court dismisses the appeal and agrees with the finding of the trial court, then he has no option except to take back the claim and present it in a court. And here there are some practical aspects which are not explained in the civil procedure code, which you have to learn only by way of practice. What is that? Now, when you file a plaint, along with the plaint, you file documents, you file the wakalat, and you also paid the court fee. After serving, the defendant entered appearance, he filed wakalat, lawyer filed wakalat, then he also filed a written statement. Then it is the issues raised. Now, after this finding is given, when you say return, what is that you have to return? Are you returning the entire file? Or, as the section states, return the plain. So, normally what is to be done and what is the practice in our courts is, though all those papers are there on the file of the court will return only the plaint and only the plain. The court will retain the wakalat. If original documents had been filed, it will not be returned. They have to take back the documents. On the side of the defendant, his wakalat continues to be on the record. His written statement also will be continued to be on record in this court itself. It will not be returned to him. Because when the plaint is returned and represented in a proper court, he has a right to file a written statement in that court. So this written statement filed in this court ends here. Wakalat also will be retained here. Plaintiff's wakalat also will be retained here. What is given back is only the plaint. And original documents are filed, they will also be retained so that he can prosecute the matter in the other court. Once plaint is taken back, you cannot make alterations and additions. It has to be filed in the same fashion. If you want to amend, by all means you can do it by filing an application before that court. So the document should not be in any way manipulated. You have taken the plaint, you present it in the court which has jurisdiction, and then in that court do whatever you want. So this is something which you don't get it in the CPC, but it is the practice. Then the question arises. Say, for example, you have filed a suit in this court on the last date of limitation. It took 1 year for the court to find out it has no jurisdiction. Now it is returning the plaint today. In the court where the plaint is represented, the suit is deemed to have been instituted on the day the plaint is presented. And the question of limitation, you have to calculate on the day it is presented. If on the last day you have filed it, 1 year has lapsed, certainly the suit is barred on the day you represent it. For that, the practice which is followed is, if the plaint is returned to you in Bangalore, and the court in which you are going to represent it is also in Bangalore, then you must represent it on the very same day if you want the limitation to be seen. You have taken back the plaint from this court, go and file it in another court. How much time it takes? Assuming it is in a different place, it should not be more than 24 hours to reach that place. So if you file it, and the next day it is a limitation. If there is 1 day delay, limitation will not come to your risk. Because there are some judgments which says you can seek for condonation of delay under section 14 of the Limitation Act, stating that I was prosecuting in a wrong court. That's a very dangerous step. The best thing is, take back the plaint. If the court is in the same city, go and file it in the same city. If you have to travel, so for example, you have taken back the plaint in Bangalore, today every place, Tumkur, Kolar, wherever, whichever is the near place. You will not be filing it in Bidar or Raichur, it will be near places. So maximum is 24 hours. There is no statutory provision to this effect. This is the practice which is followed by the courts. And it is not a continuation of the original suit. Please understand. Once that court rejects, returns the plaint, is over as that court is concerned, the suit is disposed of. It is a disposal for the judge. And therefore, that suit comes to an end. Here, the suit starts as if it's a fresh suit. The only concession made is whatever court fee you have paid there, that is saved. If the same court fee is payable in this court, you need not pay court fee. The same court fee will hold you. Assuming on the day you filed the suit, there was a particular rate of court fee paid. Time has lapsed. On the day you are representing it, there is a variation in the court fee. You have to pay the court fee, which is payable on that day, maybe minus what you have paid. So these are some of the practical aspects which a practicing lawyer over the years will understand. And therefore, after the plaint is presented, the defendant will have a right to file a written statement. So therefore, this is the practice which was there in Karnataka. I could say I am a part of the Karnataka judiciary as a lawyer, as a judge. This is precisely the procedure which is followed. You know, once you file a suit here, summons has to be sent. Earlier, not less than a year, it used to be taken. Then 1 year for filing a written statement. Then framing of issues 6 months. Then our argument, orders 2-3 years from there. And if the plaint is returned, when you present it there, again the same exercise has to be done. Issue summons, he is to be served, he will appear, then written statement, then issue, then. So therefore, in 1976, an amendment was brought in. That is 10 capital A. So the purpose of the 10 capital A is speedy trial. How do you cut short the trial? This is inevitable. If you have no jurisdiction, you can't change the law. If you have no jurisdiction, that court can't pass a decree. In the case of pecuniary territorial jurisdiction, the law says return the plaint so that you can present it in the other court. It's a question of misconception about the courts. Suit is of civil nature. Civil court has jurisdiction. Whether it should be filed in the lower court or the higher court. That's all the content. Therefore, return it. Let not the party suffer. So therefore, there was a delay. To overcome the delay, this 10A was brought in. Before that, when you return the plaint, court will pass a considered order. In addition to that, what it is expected to do was, on the plaint itself, the judge shall endorse the date of its presentation and return, the name of the party presenting it, and a brief statement of the reasons for return. So you must say, the plaint was presented as a date, plaint was presented by the plaintiff, an order is passed under Order 1, Rule 7, holding that this court has no jurisdiction, and today the plaint is returned. Why? As I said, to save limitation. If within 24 from the date on which the plaint is returned, as is clear from the endorsement, if it is present in another court, suit is in. So this is the procedure. And as I said, if anybody is aggrieved, he is at liberty to prefer an appeal. And if he is not aggrieved, if he is prepared to accept it, then an option is given to him under Rule 10A. What is that option? The object is speedy trial, save time. The judge, after coming to the conclusion that he has no jurisdiction, by virtue of Section 10A, has to tell the party, look, this is what I am going to do. This is what I am going to do. I have come to the conclusion, I have no jurisdiction. Why? An opportunity to give to the plaintiff so that he can make an application under 10A and tell the court and the opposite party in which court he wants to present the plaint. So that the court, after return, can say, allow that application and say that the plaintiff is presenting this represent plaintiff in such and such a court and on such and such a date, and the parties are directed to appear before the court on that particular day, so that this entire time taken for issue of summons could be avoided. So let us read that point. Power of the court to fix a date of appearance in the court where plaintiff is to be filed after it is done. Where in any suit, after the defendant has appeared, the court is of the opinion, after the defendant has appeared, if the plaintiff is ordered to be returned, even before issue of notice, 10 years no application. He takes it back, he files it somewhere else, from there the suit goes. This is a case where the defendant has appeared, he has contested the matter, and then the court has directed return. Where in any suit, after the defendant has appeared, the court is of the opinion that the plaintiff should be returned, it shall, before doing so, intimates a decision to the plaintiff, a peculiar provision. A party should know what happened when he pronounces it. This is an exception. Before pronouncing, the court can say, look, this is what I am going to do. I am of the view that I have no jurisdiction, and I am going to order for return of the plaintiff. So once the intimation is given to the plaintiff or his counsel, when an intimation is given to the plaintiff under subsection 1, rule 1, the plaintiff has an option. What? He can make an application to the court, A, specifying the court in which he proposes to present the plaintiff after it is done. Court is not going to tell you where it should be presented. That's it. Fine. That's a decision that the plaintiff has to take. Specifying the court in which he proposes to present the plaintiff after it is done. Then, praying that the court may fix a date for the appearance of the parties in the said court, and requesting that notice of the date so fixed may be given to him and to the defendant. So he must make an application. Under 10A, he must make an application. That for the reasons mentioned in the accompanying affidavit, this honorable court may please to permit me to present the plaintiff in the third additional civil judge senior division to court, or in the civil judge senior division to court, and the hearing date may be fixed as so and so, and notice may be given to both the parties for appearance on the day. Where an application is made by the plaintiff under sub-rule 2, the court shall, before returning the plaintiff, and notwithstanding that the order of return of the plaintiff was made by it on the ground that it had no jurisdiction to try the suit, fix a date for the appearance of the parties in the court in which the plaintiff is proposed to be. Say, I duly intimated to the plaintiff. Plaintiff has filed an application under order rule 10, giving these particulars. Hence, I pass the following order. Plaintiff is ordered to be returned for presentation to proper court. The parties are directed to appear in such a court on such a date at such a time, and parties shall take this itself as a notice, and no fresh notice will come from the court. This is what the court. Summons substance of the order to be passed by the trial. Once that is done, what is the consequence? Where the notice of the date for appearance is given under sub-rule 3, it shall not be necessary for the court in which the plaintiff is presented, after its return, to serve the defendant with a summons for appearance of the suit, unless the court, for reasons to be recorded, otherwise directs. B, the said notice shall be deemed to be a summons for the appearance of the defendant in the court in which the plaintiff is presented on the date so fixed by the court by which the plaintiff was returned. So therefore, it becomes very clear. You need not serve summons. This order itself is a notice of the court in which the plaintiffs were presented, the court in which they have to appear, the day on which they have to appear, the time at which they have to appear. Once the plaintiff makes this application, what is the consequence? So rule 5 says, where the application made by the plaintiff under subsection 2 rule is allowed by the court, the plaintiff shall not be entitled to appeal against the order returning the claim. So once the court says, I have made up my mind, If the party is not willing to accept that finding, he can say, please proceed to pass orders. I don't agree, I want to challenge you. But if he doesn't say it, and in pursuance of the intimation, he files an application under Order 7 Rule 10A, then his right to challenge that order is gone. He has to only comply with that order to be passed, take the return, present it to the court in which he has jurisdiction, and then await the other side to appear and take further instruction. So this is a provision where the interest of the parties is protected by the statute in the event of a professional man like a lawyer is committing a mistake. Parties come, they pay your fee, they think you know the law, and it is for the lawyer to decide in which court to file. If either by way of inexperience or overconfidence or any other motive, the lawyer were to choose a wrong court, well, it happens, but the client should not be made to suffer. He has paid the court, he has paid the lawyer, he has undergone this torture. So the law says, all right, give me no more charge. Return the client, present the proper court, conduct the case. Everything is fine. So as far as possible, this also should give an indication to the lawyer that this is a jurisdictional matter which you cannot so lightly treat. That's why I said the plain CPC is so beautifully drafted in 1908, making provision for irresponsibleness, laziness on the part of the lawyers and the parties. In spite of it, if you don't take sufficient interest, precautions, and the suit is delayed, not because of this defect in the CPC, because of non-understanding of the CPC or any other extraneous circumstances, the minimum that is expected of the members of the legal fraternity is not to blame the CPC. Not to blame the CPC. So this is about return of a plea. Now, Order 7, Rule 11, the next provision, speaks about rejection of the plea. Here there is no mercy. Here there is no mercy to the party or to the lawyer. If you are not alert, if you don't know your professional work, the party pays for it. Plea will be rejected. When the plain shall be rejected in the following cases. 6 cases are given. What are they? A, this is the most important. Where it does not disclose a cause of action. We have said a cause of action is a bundle of facts, material facts, which make up for a case. I pointed out to you under Order 6, Rule 2, what a plain should contain, what a plain should not contain. And if a lawyer is unprofessional, if he does not take sufficient interest and understand the significance of these provisions, it is possible that he may have gone writing, as I said, a Shakespearean language. Shakespearean language is nothing to do with legal law. When you draft a plain, your client has a right. That right, according to him, is infringed by the opposite party. And therefore, he has come to court for a relief. So what is that right? If you have it in your head, it is not sufficient. What is there in your mind should be reflected in writing by way of applying, setting out the facts which give rise to that right, setting out the facts which gave rise to the cause of action for the suit, and then the relief sought for. Therefore, when we say it does not disclose the cause of action, in the case of defective drafting, not that he has no cause of action. The lawyer who drafted the plain did not know how to draft the plain. Don't blame the party. Party has no role to play. But still, the law is very adamant. It is not showing any mercy to the party. If your lawyer commits a mistake, if you have engaged a lawyer who does not know how to draft a plain, sorry, plain is rejected. No option. No question of returning it, set it right and come back. No, reject. Therefore, is a rule of procedure, a procedure of substantive nature. So therefore, when you read a plain, as I said, you read a plain, you must understand what you are saying. That's why I said if you write 20 pages, 30 pages, 40 pages, all sorts of nonsense, we don't know what the case is. There's no use in saying this is what the Supreme Court has said, this is what the High Court has said, this is what Mullah's Transfer Property Act says, this is what, there's of no use. Come to the case. What is your case? Who is the plaintiff? What is his right? Who is hurting his interest? When did he hurt his interest? What is the nature of hurt? And what is the nature of consequence? What is that he wants? This is all. Simple English language, legal language. I would say simple English language. So when the plaint is read by the court as a whole, it should be satisfied there is some right which is sought to be infringed. On the contrary, when we read all these things, if the court comes to be manifestly vexatious or meritless, in the sense not disclosing a clear right to the suit, the court may exercise its power under this rule in the law. Sometimes people may explain, oh, I have read this, I have written this, I have taken this passage. We are not concerned about it. Before us, there is a party. Court is answerable to the party. Please tell us what your case is, what your right is, in a simple words. I should not be made to take a dictionary to understand your language. I should not be made to read Supreme Court judgment, High Court. That's the stage, the last stage. When I read the plaint, I must understand what you are saying. In fact, one of the complaints against the Indian judiciary is, which is the root cause for delay in disposal of cases. Let me tell you, 4 amendments to the CPC was brought. An expert committee was constituted of outsiders from the country. They said that is not the reason. They are given 2 reasons. One is, in the Indian judicial system, there is no early judicial intervention by the judge. The judge opens his eyes at the stage of arguments or at the stage of hearing. But he is expected to interfere at every stage. At the beginning, he must know what the case is. It is not there in our judicial system. The second thing is, the litigation is controlled by the party, not the judge. These are the 2 things which are the root cause for delay in disposal of cases. Therefore, it is said, when a plaint is presented, what happens in your courts? Solicitor puts up an order sheet. It comes up before you. Just say, issue summons. He is least bothered about what the case is, who are the parties, what is the relief sought. And we have accepted that as a procedure. So what does this provision say? This provision categorically says that the plaint shall be rejected where it does not disclose cause of action. The judge is also a lawyer. He also knows the law. Is it necessary for him to wait for the defendant to enter appearance and point out to the court that the plaint does not contain cause of action? In my understanding, before ordering issue summons, I tell the judges, you have to look into the plaint. If they look into the plaint and strictly follow this provision, take it from me, 10% of the plaints will be rejected even without the defendant's appearance. Especially a judge over the years gets specialization, experience. You can make out. As days pass by, as experience is gained, it's very easy to handle for you. Therefore, it is the duty of the court under Order 7, Rule 10 to examine the plaint before issuing summonses and to ascertain whether any cause of action has been pleaded and whether any relief has been claimed against the defendants, and to determine whether the plaint should be rejected or returned. If there is an amendment is required, rejected. So therefore, in order to find out whether the plaint discloses a cause of action, which is a condition precedent for the court to entertain the plaint and order issue of summons, what is to be seen? The law is very clear. The averments made in the plaint alone are germane to the consideration of the matter. The plea taken or to be taken in the written statement is wholly irrelevant. So while deciding to reject or not to reject the plaint, what is to be seen in the averments in the plaint? Please see the wordings. The plaint shall be rejected. Plaint shall be rejected where it does not disclose the cause of action. So to find out whether the plaint discloses cause of action, the only document to be seen is the plaint. So therefore, if the plaint discloses a cause of action and If the averment do not show that it is barred by law of limitation, then then question of rejection will not arise. But if the averment in the plaintiff itself shows it is barred by 10, it has to go. Similarly, when a defendant alleges so many things, fraud, undue influence, on that ground you cannot reject a plaint. Nobody in the plaint set out the fraud they have played on the defendant. It is the allegation of the defendant. What the defendant says in the written statement is totally irrelevant to consider whether the plaintiff discloses cause of action or not. And therefore, we have a huge case law. And especially in the election petitions, the entire this provision is comparable to section 87 of the People Representation of Act of 1951. Most of the election petitions are rejected on the ground of not disclosing the material particulars of the cause of action. In the civil suit, we are not so strict. In the election law, you see the judgments. But it is of utmost importance. You cannot show something to the court. I said it's a professional matter, it's a legal matter. It is not mere English. The person who drafts the plaint should know what the law is, what is the substantive law, what is the procedural law, what is the adjective law, how much to plead, what not to plead, what is the consequence of pleading something. You must draft only 2 pages, but this entire, because today people are very eager to appear in person because they think the lawyer is useless. Because he knows his case and he will catch hold of a section, catch hold of a judgment, he thinks it is entered. Unfortunately, it is so. Because sometimes the lawyer's performance is so horrible, the client gets a feeling he is better than them. But it is not so. Drafting of a plaint is not a mere English essay writing. Before you draft a plaint, you must know the law. What is the substantive law? Then you must know what is the procedural law. Then you must know what to prove, because when you take up a plea, you must know how to prove it. Therefore, you must know evidence act. And then if there is any judgments on the point, all this should go into your mind. And then in the simple language possible, you have to draft the plaint so that the judge understands, the other side understands. And therefore, if the plaint is not in conformity with the requirements, that is, if it does not disclose the cause of action, the court has no option except to reject the plaint. Of course, if there's a borderline case, it may be like this, it may be like that. The rule of prudence says, better don't do it at this stage, you can do it afterwards. Go on with the trial. Sometimes it so happens, it is argued. Look, this particular thing is vexatious. Therefore, you reject the plaint. A plaint cannot be rejected in piecemeal. Either you retain the plaint or you reject the entire plaint. There cannot be any piecemeal rejection of a plaint. Further, there is a provision, Order 6, Rule 16, striking out the pleading. If something is vexatious, scandalous, defamatory, you file an application, get that particular thing struck off. But it is not a case of rejection of plaint. Either you have the plaint or you reject the plaint. Partial rejection of the plaint is totally unacceptable. Law doesn't recognize this. So therefore, the sum and substance of this provision is the plaint which you have drafted should show what is the right of the plaintiff, how that right is infringed, in law what is the remedy which is available to him, and what is the relief sought for, and when this injury occurred, because for any person to come to court, there is a bar of limitation, that it is within limitation. So therefore, this is the minimum requirement which a plaint should contain. If the plaint does not contain, it is no plaint in the eye of law, it should be rejected in limine. So therefore, as I said, drafting of a plaint is an art. However intelligent you may be, however well read you may be, this is something which you have to practice. Today, unfortunately, everything is on typewriter, computers. I don't know what is the benefit, because as we are concerned, we did not have these benefits. Typing machine itself was a luxury. So we were expected to draft the plain. I had a very tough master. He used to say, draft the plain. Night I write. When I give it to him in the morning, he says, what is this? It is so lengthy. Make it small. It should be free writing, like a privy council judgment. So next day I will make it less. Then he will say, what is this? No. You must state some facts. It is too short. So like that, if the plaint is drafted half a dozen times, then you get it. And this exercise you will not be doing it throughout the life, especially youngsters, law students and lawyers who have entered the profession. My sincere advice is write it in your hand. That will enable you to marshal the facts. That will enable you to put the statement in a very concise form. You read the Privy Council judgments. It doesn't read for more than 2 pages or 3 pages. Whereas our Supreme Court judges runs to 300 pages, 400 pages. Of course, the English was their mother tongue. English is not our mother tongue. So therefore, we have that. But still, we have to try to make good these deficiencies. And my sincere advice to the youngsters who are entered the profession recently or without, if you want to draft a plain, please put it in writing several times, write it, correct it. Then, even after 10 years, there is no necessity for you to read that plain. It will be in your mind. And when you stand up for argument, there is no necessity to look into plain. You know, as I said, in which para, what you have said, in what para, what is mentioned. You can see it all aid in advancing your advocacy. These are all tools which a lawyer should possess, practice, so that he will emerge in the end of the day as a good lawyer. Now, that is one ground. The law also says, when I said valuation is to be done, court fee is to be done, the engineer to the lawyer, as far as possible, they would like to avoid paying court fee. Whatever may be the motive, why should you pay the money to the government? It's the argument. Therefore, B says, where the relief claimed is undervalued, and the plaintiff on being required by the court to correct the valuation within the time to be fixed by the court, free to do so. When this one is territorial jurisdiction, another is pecuniary jurisdiction. Once the relief itself is undervalued, other side has a right to come and tell the court relief is undervalued. Then the court has to go into the question because of Section 11 of the Court Fees Act. Court has to decide what is the court fee payable. Because unless the proper court fee is paid, there is no plaint in the eye of law. So the court holds what is paid is less and directs the party to pay the balance. It holds it is undervalued and the court will call upon the party to make good the deficiency and give a time. And if within the time paid, it is not paid, there is a ground for rejection because there is no plaint. Unless the plaint is duly stamped, in law there is no plaint. It is only white paper. When you affix this requisite stamp paper, it becomes a plaint. So by mistake, by error, you have committed a mistake. Now that mistake is sought to be corrected and an opportunity is given to you. And if you don't make use of that opportunity and pay the deficient court fee, that is also a ground for rejection of the plaint. The other case is, suit is properly valued, but the plaint is written upon paper insufficiently stamped. And the plaintiff on being required by the court to supply the requisite stamped paper within a time to be fixed by the court pays to do so. You have valued it, correct, but you have not paid the court fee as mentioned in the Court Fees Act. The court will point out to you, look, this is the difference. Pay the difference. I give you 30 days time. You have to pay it. If you don't pay, reject it. Maybe you may ask for another week's time, 10 days time, 1 month's time. Sometimes in the past, times are given for years. All those days are gone. Now, the power of the court to grant time is also taken away. Section 145 said, gave the power. Now they say it can't be more than 30 days. So therefore, when an opportunity is given to the party to make good the court fee, if the court fee is not paid, that is also a ground for rejection of the claim. And the last and the important thing which normally troubles the judges and lawyers is, it says, where the suit appears from the statement in the plaint to be barred by any law. So therefore, the first is, you have not drafted the plaint, it does not disclose cause of action. Here, plaint is properly drafted, properly valued, properly stamped, but there is a bar created by a law for its maintainability. It's called the maintainability of the suit. It is not a question of want of pecuniary or territorial jurisdiction. Under Section 9, suits of civil nature, all suits of civil nature are cognizable by civil courts unless they are expressly or by implication barred. So there are so many laws which bar the judicial civil court to entertain a suit. So by a mistake you have filed it here and there is a bar, what the court should do? Court will not return it to file it in the court where that law says no. Only ground if it is a pecuniary jurisdiction, territorial jurisdiction, plaintiff is returned. In all cases, plaintiff is rejected. You take the risk. If you have not chosen the correct court, you take the risk. So barred by law. So therefore, again, it tests the lawyer who has drafted it. You have drafted a beautiful plain, but you must know there is no prohibition in law. To give few examples. Now, section 80 of the Civil Procedure Code says, if you want to file a suit against the government, you must issue a statutory notice, give them 60 days time, and in the plain, you must say that I have issued a statutory notice and produce a copy of it. You don't issue a notice. You file a suit. Because you have not issued a notice, there is no reference. Law expects the the court to apply its mind before issuing summons. He knows the defendant is a government of Karnataka. Then immediately the judge should go to the last paragraph. Because one para you must aware that the statutory notice is has been issued and it is duly served. If that para is not there, copy of the notice is not there, the court has no jurisdiction. There is no question of court returning the plaint and asking you issue notice and file it. It will reject the plaint. And if he has issued a notice, he has to wait for 60 days. He issues a notice and then files it. Again, if the leave of the court is not taken, again, the suit is not maintainable, barred by law, and it will be rejected, not returned. Now, for example, take a nationalized bank, files a suit for recovery of 20 lakhs and files the suit in city civil court. There is what is called as a Debt Recovery Tribunal Act, specially constituted for suits to be filed by financial institutions where the subject matter is about 10 lakhs, civil court has no jurisdiction, it has to go for the Debt Recovery Tribunal. The civil court has no jurisdiction to return the plaint for presentation to proper court in the Debt Recovery Tribunal. Tribunal is different, court is different. It has to reject the plaint and it will be rejected. Then we have what is known as limitation. Limitation is a mixed question of law and fact. No doubt, section 3 of the Limitation Act says, though limitation is not set up to the defense by the defendant, if the suit is barred by time, the suit shall be dismissed. But before you reject a plaint, you must be sure. Assuming in a plaint, the court, there is an amendment, suit is in time. That is sufficient for the court to give jurisdiction. It is for the defendant to show that it is not in time, and after trial you can pass an order. On the contrary, the court will say the suit is in time because the limitation starts from the date of acknowledgement under section 18 or 19 of the Limitation Act. And from that day you calculate. It is filed after 3 years and 3 months. This is the amendment in the plaint. You say this is the date of acknowledgement. Date of suit is very clear. Calculate it. It is not in 3 years. Then the court can do it because section 3 says so. But anyhow, question of limitation is a mixed question of law. Generally, that issue should not be derived even as a preliminary point or a preliminary issue, and plaint cannot be rejected solely on the ground when the availments in the plaint do not disclose that it is barred by time. Then the defense taken by the defendant is at liberty to take a defense and he is at liberty to prove it also, but not a case for rejection of plaint. Then also we have what is called as misjoinder of cause of action, non-joinder of cause of action, misjoinder of parties, non-joinder of parties. All these objections have to be taken at or before the settlement of issues at the earliest point of time. Why? If such an objection is taken, an issue will be framed. Still, it is open to the plaintiff to rectify the claim. If there is a misjoinder of cause of action, he can remove that cause of action. If there is a misjoinder of parties, he can remove it. If there is a non-joinder of parties, he may add them parties by filing an impleading application. But that is not a ground for rejection of the claim. Maybe in the end of the day, if he doesn't do that, issue is framed, decided, suit can be dismissed. That is dismissal. not reject. You must know the difference between return, rejection, and dismissal. All the three have a distinct connotation in the eye of law. Rejection is not return. Both of them is not dismissal. Dismissal either for default or on merits. Rejection, any of the grounds mentioned in Order 7 to 11. Returning it, want of pecuniary jurisdiction or territorial jurisdiction. Therefore, you must bear in mind this distinction. And if you confuse yourself, then you will become a laughing stock. Now, in the recent amendment, two more grounds are added. Now, the plaintiff is to be filed in duplicate. Earlier, it was not so. Now, the law says if it is not filed, give an opportunity to the party to file one more. But if it persists or refuses to file, then it is a case for rejection of claim. Again, not dismissal, rejection of claim. Then, similarly, you are expected to pay process fee in terms of the order within 7 days. You don't pay. Then you see that the rule of law is upheld. Amended provisions are given effect to. And it is brought to the notice of the members of the board, the amendments are done. The purpose of amendment, if that is, the rule is not enforced, the very purpose of amendment will be failed. Again, they could reject the claim. Now, once the court decides to reject the claim, what is that the judge is expected to do? Rule 12 speaks about that. Where a plaint is rejected, the judge shall record an order to that effect with the reasons. He should give reasons. No order without reasons is a nullity. Your reason may be good, bad, ugly, but it must contain reasons. And this provision is mandatory. And unless the court records an order, the plaint is still deemed to be on the record of the court. Now, once the plaint is rejected by order of the court, the said order also could be challenged. But for all practical purposes, though the order is rejected or plaint, it is an appeal. An appeal lies under section 96 of the Civil Procedure Code as if a judgment and decree on merits is passed and no revision lies. It's a regular appeal. Now, the court has pointed out these defects and rejected the claim. The party has two options: challenge it in appeal, seek the review of the court, correct it and come back, or you can file a fresh suit. Fresh suit is not barred. The rejection of a claim on any of the grounds herein mentioned shall not of its own force preclude the plaintiff presenting the fresh point plaintiff in respect to the same cause. In this respect, same cause of action, he can file a suit subject to law of limitations. Plaintiff is not properly, it does not disclose cause of action. The youngster has filed it. Then go to a senior lawyer, an experienced man, try to find out how a plaintiff is to be framed. Frame it. Only thing is the party will be paying 2 sets of court fees. That's one there. But when you file the second suit, if it is barred by limitation, you are in trouble. So therefore, an order rejecting the plaint is like a decree, appealable, and such an order of rejection would not come in the way of filing one more suit, rectifying the defects. Whereas in the case of a judgment and decree, you cannot file one more suit. You are agreed, you have to file an appeal. Otherwise, it operates as a judicator. In other words, an order rejecting the plaint would not operate as a adjudicator if the plaintiff chooses to file one more suit on the same cause of action, probably curing the defect which is pointed out by the judge in the order rejecting the plaint. So therefore, most of the time of the courts is spent in this without properly, in what cases it would be written, in what cases it would be rejected, in what cases it should be dismissed. So you have a lot of case law, conflicting law, sufficient confusion is also created. The best thing is go by the statute. Statute is simple, it is clear. An interpretation of a statute will arise only when there is ambiguity in the provisions. Now today, the judgments and interpretations are creating ambiguity. Section is very clear. It is very simple. You don't need a dictionary. You don't need anybody's expert to understand. Only thing is, you must read it properly, understand, and then try to implement. Of course, experience has its own advantage. For a period of time, you will learn. So with this, I will stop because I know there are a lot of questions, especially on this. I would like to see what the young members of the bar feel about these two projects.
Thank you, sir, for sharing your profound knowledge with us. Moving on to the question and answer session. So the first question is whether plaint can be rejected for non-jointer of purchaser of suit properties in a suit for partition before preliminary decree.
Return of plaint is only on the ground of want of territorial and pecuniary jurisdiction. Rejection of plaint is only on the grounds mentioned in that section. Non-jointer of necessary party is not a ground for rejection of plaint. If a person who is a necessary party is not added as a party in the suit will be dismissed on that ground, not a case for rejection.
Thank you, sir. So the next question is, if the plaint is filed 10 days prior to the expiry of limitation period, and when the plaint is returned, does the plaintiff have 10 days to represent it?
Maybe. To avoid bar of limitation, the plaintiff presented on the day you have taken it back. But if there is time, probably they need not be in such a hurry.
Yes, sir. Thank you, sir. And the next question is whether a plaint can be rejected merely that is this barred by limitation under Order 7, Rule 11 application, pre-trial stage.
That's what I said. Limitation is a mixed question of law and fact. If what he has stated in the plaint, without it being traversed by the defendant, shows plaint is barred by time, certainly the court will be within a jurisdiction to reject it in view of Section 3 of the Limitation Act. But if the plaintiff says the suit is in time, then whether it is in time or not is a question to be decided during trial. Merely because the defendant in written statement say how the suit is barred, by looking into the averments in the written statement, plaint cannot be rejected on the ground of limitation. Unless the plaint discloses that the suit is barred by time, on the version of the defendant, on the contents of the written statement, on the basis of the documents produced by the defendant along with the written statement, a plaint cannot be rejected on the ground of limitation.
Thank you, sir. So the next question is, if the plaintiff has not exercised his option of filing an application under Order 7, Rule 10A, Clause 2, for making appearance of defendant in the court of his choice as a discretion, can the decision of return informed by the court per se appealable without making any such application as specified above in relation to Sub-Rule 5 of Order 7, Rule 10A?
See, court is expected to intimate the plaintiff with decision. When it intimates that I am going to return, plaintiff has to make good. Assuming that he is not sure what he is going to do, he may tell the court, look, I want to challenge your order. Then the court will order for rejection of the plaint, return of the plaint. Maybe there is nothing in CPC which prohibits the plaintiff from filing one more application, requesting the court to say, permit him to present the plaint in a court and fix a date of hearing. I would say, given the option, I would say the court still has jurisdiction. It has not become functus officio. For the purpose of Section 10A, probably the court can enter in that application and pass an appropriate law.
Yes, sir. So one last question for the day. A suit is filed against a dead person. Can the legal representatives of the dead person file an IA for rejection of plaint? Can it be denied if the plaintiff files IA for abatement and bring to LRs on record after the IA and for rejection is filed?
When a suit is filed, according to you, defendant is dead, right?
Yes, sir.
if the defendant is that suit abates, where is the question of rejection of plaint? But after abatement, an application is filed for setting aside abatement to bring the LRs on record, and then the LRs are brought on record. Then if the LR wants to file an application under Order 7, Rule 11 for rejecting the plaint, it is permissible. But if the suit is abated, already suit is not there. The whole object of rejection of plaint is the suit should go. Suit has already gone. Suit is not alive. When the suit is dead, where is the question of rejection of plaint?
Yes, sir. Thank you, sir. And one last question, sir. If the defendant files for dismissal of a suit on the basis of limitation period, on whom does the burden of proof lie?
Normally speaking, when the plaintiff comes to court, he must show that he is within time. It is immaterial in what way that issue is framed. Whether the suit is in time, in view of Section 3 of the Limitation Act, always the burden is in the plaintiff to show the suit is in time. He will simply enter the witness box and say it is in time. Then the burden sits on the other side, who is saying it is not in time, to show how it is not in time. So the question would be, on whom the burden lies is not. Is the suit barred by right? But purely a question of law. Of course, based on facts. It is a mixed question of law and fact. When a plaintiff files a suit, an obligation is cast on him to show that the suit is in time. If suit is not in time, court shall dismiss the suit because of Section 3. What is the evidence he has to adduce? He will say, I am suit is in time. One sentence. Then the defendant who says it is not in time, it is for him to show to the court how it is not in time. When did the cause of action arise? What is the period stipulated in the Limitation Act? On what date the suit is filed? That's what he is expected. So therefore, strictly speaking, on whom the burden is immaterial, court has to consider the question of jurisdiction. Court has to go into the question whether the suit is in time or not. Of course, it hear both the parties, it look into the evidence, it look into the Limitation Act, and then decides.
Thank you, sir, for sharing your critical reviews. I'm sure we all have learned a lot from today's session. And now I would like to take this opportunity to extend my sincere gratitude to our eminent and venerated speaker, Honorable Justice N. Kumar. And sir will be addressing on the topic Orders 17 and 18 of Civil Procedure Code 1908, that is examination of witnesses and marking of documents tomorrow. And I thank all the members of KSPC Law Academy for hosting us an important and educative session on Civil Procedure Code 1908. And I'm extremely happy to thank you all the participants who are eagerly taking part in this webinar series. You all can log in from the same meeting ID and password at 5:30 p.m. till 13th November 2020.